Hello, my name is Benjamin Hart. I'm an American attorney and the Managing Director of Integrity Legal here in Bangkok, Thailand. As the title of this video suggests, we're discussing the Department of Government Efficiency proposed. We're still sitting here some 1 week before the incoming administration is sworn in, so it remains to be seen exactly what this thing is going to look like. But what we do know is Elon Musk and Vivek Ramaswamy seem serious about cutting a lot of government inefficiency, a lot of government costs. I've done another video contemporaneously with this one, although probably published beforehand, talking about how this inefficiency is most prevalent in the U.S. immigration system insofar as USCIS and the Department of Homeland Security, when you consider them in tandem with the Department of State and various U.S. embassies around the world, frankly, their function looks pretty darn redundant to me. The function of processing a petition that then gets sent on to the embassies and consulates via the National Visa Center, and as we've discussed in other videos, National Visa Center plays a big part in immigrant spouse visa cases, not so big a part in K-1 fiancé visa cases. Effectively, for such cases, they act as a kind of clearinghouse or post office for those petitions. They leave Department of Homeland Security, they come to National Visa Center, and for K-1s, they just get sent directly to the relevant embassy. That embassy then deals with the documentation and interview. Well, all of that documentation is redundant of what's already been adjudicated by USCIS, which is what I've discussed in another video. I think that redundancy needs to be done away with, and I'm hoping DOGE does something about that to create more efficiency within the U.S. immigration system. But leaving that aside, I think it's worth pointing out, it's especially redundant, USCIS, in terms of K-1 visas. K-1 fiancé visas, although dual intent insofar as you can intend to go to the United States with an intention to eventually become a lawful permanent resident, K-1 visas are by definition non-immigrant visas. They're only good for a 90-day validity in the United States, and then that person needs to go ahead and get married and then process adjustment of status. So they're going to be adjudicated again by the Department of Homeland Security. So it raises the question, why the initial need to adjudicate the underlying petition by USCIS if it's only going to go to an embassy and the applicant's only going to end up back in the United States filing for adjustment of status with USCIS again? It's redundant in the extreme, and when it comes to K-1 fiancé visas, I've got to say, and I hope DOGE looks at this, I hope that they see that, hey, this is especially redundant in terms of the K-1 fiancé visa, and the K-1 fiancé visa is not permanent residence. I think you can make an argument that if you're going to issue a visa like a spousal immigrant visa, so somebody who's going to enter and gain lawful permanent residence at entry, maybe some extra redundancy is warranted because you want to vet those people. So, okay, maybe the underlying petition needs to be vetted by USCIS. With a K-1 fiancé visa, they're entering the country for 90 days at a max, and then they need to get married and file for adjustment of status. They're going to be scrutinized by Department of Homeland Security. They're going to be scrutinized by USCIS. Why put them under the initial scrutiny? Why not have all the K-1s done, adjudicated fully at embassies or consulates abroad, and then again, when they come to America and have to file for their green card, then they get looked at by Department of Homeland Security directly. That would create a lot less processing time, in my opinion, and a lot less cost to the American government and ultimately the American taxpayer compared to the system as it is today.